So, if you think about it, our founders gave us a First Amendment, which allows robust online speech to flourish. And the Supreme Court gave us the Sony Betamax decision, which says that if a product has a legal use, then it's a legal product. And in 1996, a far-seeing Congress tucked a provision called Section 230 inside the Communications Decency Act. And very simply, Section 230 says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. What that means is that online intermediaries or platforms that host or republish speech are protected against laws that might be used to hold them legally responsible for what others say or do. And by creating this broad protection, this provision, CDA 230, is generally credited with allowing online innovation and speech to flourish. But now some are questioning Section 230. They say that times have changed. They say the internet has grown. They say that CDA 230 should be modified or cut back. So to discuss this issue, we have an outstanding panel of experts. First, Christina Bernard. She's the Senior Corporate Counsel at Expedia, working on regulatory issues, and is an expert on government regulation of internet platforms. Prior to joining Expedia, Christina was in private practice in Seattle and Washington, D.C., and in-house at Boeing for a total of 15 years. Then we have Arthur Reiser. Arthur is the Director of Criminal Justice and Civil Liberties Policy for the Art Street Institute. If you have not heard of them, they're an outstanding free market think tank in Washington, D.C., does great work. And in this capacity, he produces online research, original research, writes for the popular press, and educates policymakers on tech policy and civil liberties issues. And he is also an expert on criminal justice reform and a former prosecutor, whose expertise I think will come in handy on this panel. And finally, Kate Tumorello. Kate is a policy manager at Engine, and Engine is a nonprofit, and they are the voice of startups in Washington, D.C. Kate works on privacy, security, and telecom policy. And prior to Engine, she worked on surveillance policy at the Electronic Frontier Foundation and as a tech policy journalist in DC at both Politico and The Hill. That is a really amazing resume. So first, let's go to Christina. Can you tell us Section 230? Like, where are we in terms of regulatory and legal policy in Section 230, and how do we get here?
Sure, I'm happy to start off. And before we kind of get to where we are now, I do want to just take just another minute to just give a little bit more background and context of what Section 230 is. And Michael covered it a little bit, but I want to make sure that everyone kind of really heard it and can allow it to sink in, because it's going to inform, I think, the rest of our conversation. Section 230 is a provision of a much larger federal statute called the Communications Decency Act, which was passed, as Michael said, in 1996. Which, as we've just learned, that's when the internet was a baby. And it was a very kind of new thing that people didn't quite know what was going to happen with it. And as the name Communications Decency Act might suggest, the real purpose, or the focus of the law in large part, was keeping kids away from inappropriate content on the internet. Now, that part of the law was struck down by the Supreme Court on First Amendment grounds. But like a little oyster tucked in a pearl was Section 230, and that has survived. It was not subject to the challenge. Now, Section 230 is largely credited, and I would agree with this, as being either the most significant factor, or at least one of the most significant factors in why we have the internet and kind of the e-commerce that we have today. It's hugely important, and it is just a few words long, as Michael read. Is no user or provider of an interactive computer service shall be treated as the publisher or the speaker of any information provided by another information content provider. And what that means is that your interactive computer services of the world, like Google, Facebook, Amazon, eBay, Yelp, Airbnb, et cetera, they can't be held liable for the content that someone else has put on their platform. And by liable, I mean they can't be subject to penalties or fines by local governments, or they can't also be subject to damages or injunctions in civil lawsuits brought by people who are saying that the content provided by third parties damaged them in some way. And let me give you just two practical examples of how that could play out. The quintessential classic example that people, I think, have the easiest time understanding is Facebook. So person A posts something on Facebook that defames person B. Person B, of course, can sue person A for defaming them. Person A is the actual speaker of that information. But person B cannot sue Facebook for defamation and sue Facebook for having posted the defamatory content or having that on their website. Now, another example, and this comes from a real-life example that's currently percolating in the court systems, is Amazon. You know, Amazon has its third-party marketplace where third parties can come and sell goods. So a third party sells, say, a hoverboard. And let's say that hoverboard is defective in that it tends to burst into flames. And someone, of course, gets hurt. That person can, of course, sue the manufacturer of the hoverboard, can sue the seller of the hoverboard, but the Section 230 of the CDA protects Amazon from being sued by that injured person because, in that sense, Amazon is not the seller, it just posted the third-party content of someone else. So that's this kind of Section 230 in a nutshell. Maybe someone else can speak to the actual kind of purposes behind it, but I think it's important to have that background as we get started.
So the basic theory behind it is that if there is a wrong done, you go after the wrongdoer. But Section 230 is not a total get-out-of-jail-free card, right? I mean, there are exceptions.
There are. I'm happy to talk about the exceptions, but I don't want to dominate.
Go. Then we'll.
There are a few exceptions built into the statute itself. Any violations of federal criminal law is not a get-out-of-jail-free card, of course. Violations of intellectual property are not. You're not immune from suit for those type of violations that might happen on your platform. And it doesn't excuse a platform's all of their conduct. You know, you can still be sued for, you know, a breach of contract if you breach, you know, the terms and conditions or the privacy policy. Rather, it is immunity for liability that kind of flows from content that someone else has put on your platform. So it's not just a general kind of immunity from any kind of suit.
So let's go to Kate for a moment. You know, very often in the debate in DC about Section 230, it's all about Google and Facebook and Twitter. But Kate, you represent startups, and why is Section 230 important to your members? How do they use Section 230?
Sure, yeah. Very quickly, before getting to that point, just to add on to the not getting out of jail free card, there's a lot of case law around what it is to even, you know, curate or encourage user content. So it's not just like, oh, if the platform does something wrong, if the platform is encouraging you to pick a roommate based on racial discrimination, you lose 230 immunity. It's not this blanket protection. I think that's really important just to kind of frame how limited it is and why it's so precious. So in terms of startups, I think the Facebook example is a often heard one and also very limiting. User-generated content is not just about Facebook posts. It's much bigger than that. It's anytime you have a comment section on a website. It's anytime you're posting a blog post. It's anytime you're rating something 1 to 5. That's user-generated content. And if you're responding to a survey, if you're selling something on an online platform, so Facebook obviously is kind of the example everyone thinks of, but we work with so many startups across the country who do host user-generated content, and it's not like as simple as a comment on a Facebook thread. It's much more nuanced than that. And starting a startup is really hard, and it's really expensive, and it's really time-consuming. And 230 gives these small, young companies a security blanket of knowing that, you know, if one of your users uploads something and you don't have some kind of really expensive technical filter in place to take it down, or you have a small team of people who have to look at stuff manually and can't go through everything in real time, that's okay. You are allowed to host your user-generated content, and if there's a problem, you can deal with that after the fact, and you don't need to worry about, you know, when Facebook CEO, Mark Zuckerberg, testified, he said he was hiring 10,000 content moderators. We have companies that are 30 people. They're definitely not hiring 10,000 content moderators, and Section 230 gives them the security of knowing that that's okay. You can start a company, you can be small, you can be young, you can be scrappy, you can have a really small budget, and you don't need to worry that you're going to get some hugely expensive lawsuit on day 2 because of something one of your users said.
So on the previous panel, we had wonderful comments from the site Patreon, right, that hosts content from from artists, or it directs you to content from artists. So they would be, for example.
Yes, we love Patreon.
Yes.
They're good folks, and I'm sure they've spoken about it much more than I can, but they allow creators online to get paid for their work, and that's obviously a great thing. We want to see our creative industries blossom here in DC, and I think Patreon's a perfect example of tech and creative working together to make the system a better place. We kind of could have any kind of example for this, but let's say, for instance, you have someone who is the survivor of an eating disorder, and they are encouraging, they're providing inspiration and encouraging other folks to battle their eating disorder. How do you decide, okay, this is something that goes too far? This comment on this person's post is something that is actually encouraging an eating disorder, and therefore the platform should have to take it down. Section 230 gives the companies the room to say, we're going to moderate content the way we see fit. We're allowed to decide what we want on our platform, but we're not legally held responsible when users kind of jump the gun or do something that we don't want on our platform and we don't think is a great idea. And that, knowing that they can moderate content that way, they can decide what's right for their platform, for their audience. It's what makes companies be willing to host user-generated content. I think if Starbucks was held responsible every time 3 people got coffee at a Starbucks and sat down and talked about something illegal, Starbucks would stop letting you sit in Starbucks. There's no benefit to them to having that kind of liability there, and so internet platforms have the same kind of protections.
And in fact, actually, if I can just play off that, kind of what Kate touched on, that was actually kind of the original, I think, motivating purpose behind Section 230. Before Section 230 was passed, a court had ruled that because it was kind of, at that point, it was just kind of an internet bulletin board. And because the bulletin board tried and kind of made some efforts to take down kind of maybe potentially defamatory content or kind of offensive content, the court said, oh, well, since you have undertaken these efforts, you've kind of assumed this duty. And so therefore you can be liable for any kind of content that you don't catch or that you don't make the right call on. And Congress said, whoa, 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 like this is creating a totally perverse incentive. We want platforms to undertake voluntary efforts, like Facebook is doing, to kind of get rid of some of that really offensive or potentially illegal content. So we don't want to penalize any platform for undertaking those voluntary efforts. We want to make sure that they have immunity for all that third-party content.
Was that the CompuServe case?
I think so,
Yeah, I think so. Okay, so Kate made an interesting point, which is that if Starbucks were held liable for stuff that people said when they were sitting and talking at Starbucks, they wouldn't let you sit and talk at Starbucks. So let me go to Arthur. Just based on that, let's talk about like a world without Section 230. Like, what does that world look like, and what does innovation look like, and what does free speech on the internet look like?
So, I am not a tech person, to be quite clear. I still put www and then type in wherever I'm going. I can turn on my computer, and that is pretty much the extent of my technical capabilities. So I am a prosecutor. I was a prosecutor for a long time. I was on the Chapo Guzman case. And my perspective of this issue is really a criminal perspective. And we can talk about the changes to the law and why we're sitting here, and I think that Christina and Kate are probably more equipped to talk about the actual legalese of the changes and the policy points of it. But really the big changes that we're seeing is specifically towards human trafficking and the sex trade. And I always say for prosecutors, if you build it, they will come. And that is exactly what we're expecting to see when it comes to the changes in 230 and the changes that we're seeing revolving around this issue. And let me tell you, let me give you an example that is totally unrelated, but really illustrative of what I'm talking about. Anybody here remember Bridgegate? Chris Christie, yada, 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 jerks, all the way around. But does anybody know what happened after Bridgegate? When prosecutors got involved? They charged people for civil rights violations, for wire fraud. The civil right violation, the guy was convicted for a civil right violation because under the theory of the case was you had a right to be able to move. By the way, there's nothing in the code that says that, but they got a conviction on this. Somebody's going to jail for this. That was overturned, but the wire fraud stuck. It's actually going up right now through the circuits, and it will be in the Supreme Court soon. Here's the theory on wire fraud. Because you lied, the lie, for wire fraud, just so you know, you need basically 3 elements. It's a little more nuanced, but you need a lie, you need a benefit, and you need, the lie has to be transmitted over some type of electrical mode. So the lie was, I did not close these lanes for political motivation. That was the lie. The benefit was the political motivation, and he emailed somebody about it. They convicted him for wire fraud. So if I would email my wife tonight and say, I only had 3 martinis when I had 6 martinis because the benefit was I didn't want to sleep on the couch. I'm not being tongue-in-cheek here because there's other things going on. That's wire fraud under this theory. Every politician who does a stump speech that says something that's not true, and as long as it's recorded and transmitted, that's wire fraud. So my point in how this relates to this is, when you build it, prosecutors will come. We have seen this over and over and over again. Over and over and over again, we have seen this happen. In 1988, there was this a bill that was called the I forgot the name of it, Honest Service Fraud Act. And it was supposed to prevent fraud in certain cases. By the end, they were prosecuting college students for plagiarism. This is how crazy the feds will go on these types of things. This is really an overcriminalization issue. And we're seeing this with other issues. It's not just 230 and the things revolving around human trafficking. But even as an AUSA, I remember taking a case that I prosecuted somebody for conspiracy to commit human trafficking because he had sex with somebody that turned out to be a victim of human trafficking. And I used other statutes in order to make that conspiracy stick, and that is exactly what's going to happen with Cesta.
All right. Well, let's circle back around on Cesta for a moment. But I think your point is that very often in D.C. when Congress makes a law and you go to Congress and say, wait a minute, this is way too broad, and this is going to bring in all kinds of conduct under this language that you say that you're not going after, right? But it also encompasses all this conduct too, which is perhaps not objectionable or less objectionable. And the answer you always get is, don't worry about it. No prosecutor would ever bring an action on this. And what you're saying is that if you create a cause of action, it's going to be used because prosecutors prosecute. And that's always an important
And more than anything else, they'll use it as leverage.
Right.
Leverage is really important to prosecutors, and if I can get you to plead guilty for something else, and I'll threaten you with, I'm gonna charge you with conspiracy to commit human trafficking. That sounds really scary to somebody who is just doing, some computer nerd doing something on a computer. Right. That's terrifying.
Right. Okay. So let's circle back in a second. It is terrifying. I'm very terrifying. As a computer nerd, I find it terrifying. All right. So we're gonna circle back around and explore that more in a second. But first, let's go to Christina and talk about not what Congress is doing, but what's going on in the courts and in local jurisdictions with Section 230 and how it impacts you and Expedia.
Sure. So when we talk about kind of weakenings of Section 230, I think the panel, at least the kind of the tagline of the panel was focused on maybe changes at the federal level to the law itself by Congress. But there are other ways in which Section 230 can be weakened or bolstered on any given day. And the first, which Kate alluded to earlier, is how are courts interpreting and applying Section 230? The language that Michael and I both shared with you about what Section 230 says, there's room there for some interpretation, especially when you're trying to apply it to unique sets of facts, and that's what courts do. And of the 3 judicial branches, courts are the most removed from the people. They're the most out of touch, you might say. And that's not a criticism, that is specifically by constitutional design. And the other feature of courts is that they are deciding cases that come to them kind of on an individual, incremental, kind of fact-specific basis. Again, that is specifically by design. So, but what that means is, as a structural matter, the courts are really the last place you want policy being made, especially policy that affects kind of large chunks of our economy, like the e-commerce economy. And to be fair, I mean, judges would say that their role is not to make policy, that they are just trying to apply the law as it's written. But again, there's a lot of room for discretion, judgment, as well as personal feelings and opinions to come in. I mean, judges are human. And a lot of these cases or defendants that invoke Section 230 they have some pretty tough underlying facts. I mean, you're talking about sometimes sex trafficking of minors, really gory, grisly ISIS recruiting videos, someone who's purchased a gun online and then who should not have been able to purchase it and then uses it in a mass shooting. And so you have really tough underlying facts with some true victims of heinous conduct. And so you you ball that all together, and you can have courts, when faced with various scenarios and whatnot, give Section 230 a fairly narrow reading. And we're also seeing that with plaintiffs who are getting a little more creative about their allegations and what they're saying. And they're saying, wait, we're not saying it was the content that kind of caused us harm. Rather, it's the way the platforms have designed their website. It's the way that Facebook's algorithm links people with content that they might be interested in. It's how the platform processes payments for the goods and services offered by third parties. And so we're not attacking the content. We're just going after how the website's designed. Now, I would say a number of courts have seen through that, and they say, no, this is still based on content. Section 230 applies. But some haven't, and all of those cases are on appeal, and so we'll see how they come out. But I think that those cases can really present a weakening of Section 230, depending on how they come out. And then the second aspect of how they can be weakened just on a daily basis is local governments. Local governments, especially at the city level, they can pass laws very quickly. Within a matter of weeks, they can pass laws. And I in my work with Expedia, particularly HomeAway, which is a platform that offers basically a platform where people can offer short-term rentals, rent for travelers and vacationers, kind of like Airbnb. That's also an example of a platform. Local governments passing laws that impose liability, fines, and penalties on the platforms for having content that doesn't comply with the local government's laws. And as you can imagine, as we kind of touched on this in the privacy panel before this, there are thousands of cities in the United States. If a few dozen or hundreds or thousands of them each pass their own law about what a platform has to do with respect to content, kind of regarding that city, you have a patchwork of regulations that a nationwide, worldwide platform is going to have a very, very difficult time complying with, whether a startup or a company like Expedia.
So, but local governments can still regulate home sharing, right?
Of course.
But the point is, they just can't, under Section 230, they just can't go after the platform.
Correct.
Right. So often in these cases, especially in these jurisdictions that Christina's talking about, where they attempt to regulate or in some way regulate home sharing, and then somebody lists a home in a way that violates these regulations, and they go after the platform, right? Often the courts say, but this is commercial speech. They're charging money to rent their house. Does that make a difference under Section 230?
So that is an argument.
Right.
I think where there has been, I think, some tension with what local governments are doing with respect to the scenario you have, is that local governments realize that they can't tell the platforms like Airbnb, like HomeAway, look, you have to take content down if that content doesn't comply with our laws. A few local governments have done is they say, okay, we're going to pass laws that say you can keep all the content up that you want, but once you try to process a payment for that listing, that's when liability attaches. So in that way, they say we're not regulating content, we're regulating a business transaction.
Right. That's the back door.
Yeah.
But I want to rent my home is still speech.
Yes.
Right. And if we were to change the interpretation of Section 230 so that any speech involving money were exempt from Section 230, then there would be a good portion of it would not then apply to a good portion of online speech, I think. Okay. So let's switch. That's what's going on in the localities in terms of threats to Section 230. Now let's go back to Congress and let's talk about the big elephant in the room, which is CESTA and FOSTA. And I'm going to go to Kate. So Cestafasto, what is this?
Sure. So CESTA and FOSTA it was a law. It was two separate laws that got combined into one law, passed in the last Congress. It has the very noble sounding goal of cracking down on sex trafficking. You'd be hard pressed to find in DC someone who says, I am in favor of human and sex trafficking. They don't have a big lobby. There is none of them there. They don't even have a shadow lobby. It's an easy topic to talk about because nobody likes the idea of sex trafficking. And so, Congress put this proposal together. They did a very good job of bringing in folks who had really, not warming, but like very emotional stories about victims they knew, their family members who had been affected by sex trafficking, and those stories did a really good job of making the case that we need to do something. The something they decided to do was pass this law, the Stop Enabling Sex Traffickers Act, and the I don't even know what FOSTA stands for anymore. The two laws that essentially tried to do the same thing, they combined them into one. Unfortunately, that law creates a really impossible standard for companies. It says if you knowingly facilitate sex trafficking, you are responsible. You are as responsible as a sex trafficker. And we're not really sure what knowingly means in this case. And in fact, that word could encourage people to stop moderating content on platforms. It would be very easy for Facebook to say, and I'm not speaking for Facebook obviously, but a company like Facebook to say, well, if we engage in content moderation, then we might be knowing that it could exist on the platform, and then maybe we're knowing under the law, and then maybe we're liable. So it has this really weird, we mentioned perverse incentives earlier, it has this perverse incentive to stop moderating content and to stop taking in content and communicating with law enforcement to effectively actually crack down on sex trafficking. So that was that piece of legislation that passed in last Congress, and it had immediate effects. You saw Craigslist take down a lot of its personal ads. That's not at all the intended consequence. Adults who want to connect online through Craigslist's personal ad section without engaging in any sex trafficking at all had to stop doing that because Craigslist said this is not worth the chance that we get sued over this, and sued for a lot of money over this. And so I think that was kind of the starting point in talking about 230, and it was a really interesting starting point because it's such a compelling case. Of course, we all want to stop human trafficking. No one's for that. But the way Congress went about it kind of opened the door to these 230 problems.
Right, which is interesting, which also kind of dovetails with what we heard on the previous panel, right? Which is that if you're in a situation with very vague regulations and very broad liability, your every incentive is to overprotect, right?
Mm-hmm,
And the consequence of that is that there is legitimate speech that you have to take down because you're going to be hyper cautious. So under Cestafasto, as you described it, I'm just putting myself in the place of a startup, and I'm a startup that hosts pictures, right? So some user is posting pictures, and it's a picture of say him and some woman who may be his wife, and then a picture of him and some kids who may be his kids. Do I have to look at all those and make sure those people are not being trafficked, or else I'm liable? And how do I have the information to do that?
I think that's a good question. Yeah, so there's definitely a lot of, I think in general when we talk about Section 230, the black and white cases are really easy, right? If you see a Facebook post advertising for a 14-year-old sex slave, that's sex trafficking. That's easy, take that down. That makes a lot of sense. The question is, what if you see, like you mentioned, Michael, what if it's someone who could be 17, could be 19? How could Facebook know just from looking at the picture whether or not that person is being trafficked under the law, which has a very specific, sex trafficking has a very specific definition. That's not just sex work. So it definitely creates this ambiguity for platforms to have to say, okay, maybe this emoji means something in this context that we never used the emoji to mean that thing, and now we need to start policing this emoji. Of course you're going to over-police. Of course you're going to be overly cautious because the liability created under the law is not worth risking. You especially for a startup that can't survive a costly lawsuit, let alone pay for the legal cost to have a case dismissed. That in and of itself is expensive. But surviving a lawsuit can be way too costly and crippling to small platforms, let alone the big guys who I know also have to figure that out.
Right. So as a platform, your liability, your potential liability, is being determined by facts you do not have access to.
Yes, absolutely. And I think there was a really interesting Vanity Fair piece kind of inside Facebook's content moderation war room, and the Facebook's person said, like, when prosecutors are looking at the facts of a case, they can get subpoenas, they can talk to witnesses, we're looking at 100 characters. We're looking at 4 emojis. How can we, in those 4 emojis, make the same determination a prosecutor can?
Right, but then Arthur already told us that if you create an opening, prosecutors will aggressively use it because that's what they do, they're prosecutors. So let's go to Arthur for a second. So the whole point of Cestafasto, the goal, what is a noble and worthwhile goal, was to reduce child trafficking through this law. Arthur, how's that working?
Pretty terribly, actually. We don't have enough data to have a full picture. I did talk to a professor this morning. Her name is Professor McCracken from Southern Florida, which happens to be the greatest name for a professor, McCracken. And I talked to her, and I asked her, her research is really around sex workers. And I said, what impact have you seen just since this law has passed? And she said that suicides are up among sex workers about 25%. So I was like, why? Why is this happening? And it's 2 main groups have actually been impacted by this. The first, surprisingly enough, are cops. Because police, a great quote from a Vice detective in Indianapolis said, digital trail of Backpage was a godsend. And Indianapolis, just Indianapolis, the city, has seen a 75% decrease in indictments and prosecutions of pimps. Because they have no way of finding out these people anymore, because now they've just gone to international sites. And international sites, they can't just subpoena an international site. So it's really what's happened. So it's actually making police work a lot harder, which is funny enough that the police are actually coming out and saying, wait a minute, I know that we supported this, but maybe this wasn't such a good idea. That's the first group. The second group is actual sex workers. In San Francisco, there's one report that said that the amount of streetwalkers has gone up by 75%. And the amount of human trafficking has actually gone up because now women who are in the sex trade have no way of actually doing this themselves. So they go back to the old method, which is, do you have somebody that kind of controls you, which is what human trafficking is, and up to 100% increase in human trafficking just in San Francisco. So it's actually made everything worse. And I will just challenge a little bit this idea that the people who put forth Cesta were noble. I do think there was a large group of individuals that went forward on this bill in an effort to try to make it harder for sex workers to be in business in the first place. And I know this because I fought this with Zach Graves and Sasha in DC, and the people that showed up and challenged us were the far-right Christian groups, and this is one of the big things that they talked about. So that's anecdotal, but that's my experience with it.
Can I just add on a point here? You mentioned Backpage, so I think a really important thing to note is that Backpage was shut down before Cesta was even enacted. Yep. And Backpage was, according to every report, including the Senate's investigation, a bad actor. They intentionally sought to help their users evade filters to detect sex trafficking. And without a question, Backpage did the wrong thing, I think. Everyone can agree on that. And they got in trouble for it, and Section 230 did not help them at all. Right. So Backpage was shut down before Cesta was even enacted, and arguably, at least nominally, I think Backpage was kind of the target of Cesta. When we talk about the bad actors, we all think of Backpage. And so the idea that we needed this law to shut down this bad actor isn't even true, because we shut it down without the law. So I think that's just an important...
And there was already prosecutions ongoing. There are already tools to go after these people. And one of them would be conspiracy. I think that there was a very strong case for Backpage with a conspiracy for certain human trafficking, because there was evidence that they actually knew, they affirmatively knew that some of the platforms being used by pimps, and they still did it anyways and weren't aggressive in trying to prevent that. And so there were actually prosecutions that were happening. And most of those prosecutions have actually skidded out because of the laws changed to the point where they're not necessary.
So can I just, I do want to take just a little bit of issue with something that Kate just said, and that is Section 230 actually did help Backpage for a little bit. In fact, the leading case out of the First Circuit Court of Appeals is a Backpage case that provided immunity to Backpage for suits alleging that they had allowed underage trafficking. But I think what ultimately brought them down is kind of the police work, is like getting Backpage and punishing them for things that like kind of Backpage was actually doing, as opposed to just kind of the content on their site.
Right. So good. So just to move on, just out of curiosity, so is Cestafasto, is this now we've done it, we're done with Section 230, or is this the beginning of the Swiss cheesing of Section 230? Now that we've dealt or allegedly dealt with child trafficking, do people have other things on the list they also want exemptions for?
Yeah, I would love it if this were the end and we dealt with it and it would be over. But no, we've already seen lawmakers point to things they want to use 230 fixes to solve. And I think that kind of ignores the whole idea that bad things on the internet aren't bad because of the internet. They're bad because of the people doing the bad things. And so we've seen lawmakers talk about using 230 tweaks to address opioid sales. We've seen lawmakers talk about using 230 fixes to address gun sales, to address things like anti-conservative bias online. It just opens up this Pandora's box that, Section 230 really was one of the foundational laws of the internet, if you talk to most folks who care about the internet. And the Swiss cheesing will really hurt the internet. It'll hurt free speech online. It'll hurt the big guys, but it will really, really hurt the small companies who are just getting off the ground, who want to just be able to host photos that their users upload.
Yeah, and Section 230, I know we talked a little bit about the purpose of it, and kind of it was, one of the purposes was to kind of encourage platforms to moderate their own conduct. But that was not the only purpose of it. I mean, as you said, think about the internet was in its infancy. Congress wanted to encourage innovation and growth and competition with what this internet was going to become. They maybe didn't know exactly what it was going to turn into, but they didn't want it to be kind of strangled at the outset by excessive regulation or lawsuits. And so as you start kind of picking away at it, you also start kind of picking away at the original purpose of it.
And one little thing that I was add to something Kate said was, I have been in rooms with people that were on my side when it came to Cesta that have now almost flipped when they're talking about the conservative. There's this big conspiracy that the internet is being biased against conservatives. Believe it or not believe it, but they have now seen this as, oh, this is a weapon that we can use. So like the actual people I talked to that were on my side have now kind of flipped to the other side, seeing this as a target opportunity.
Well, that's an interesting point. So everybody who has used the internet, which is everybody in this room, we've all had the same experience, right? Where you get on the internet and you get like very angry about that thing, right? Like whatever that thing is, but it is outrageous, it is terrible, it should not be there, and it makes me very angry. And before, you couldn't do anything about it, right? Because of Section 230. But now maybe you can. Right? So my question is, will the Swiss cheesing lead to more lawsuits against startups? And Kate, is that a problem? And how do startups deal with it?
Yeah, I mean, I think the easiest way to deal with it is to stop hosting user-generated content, or if that's obviously what your platform is, to put in place really costly filters, to hire 10,000 content moderators, the things that the big companies, Facebook says they're doing. That's not possible for a lot of the companies we work with. And so you either stop offering the service that relies on user-generated content, or you just hold your breath and hope. And that's not a real good business strategy, and I don't think our company's lawyers would advise them to do that.
Right,
No, they won't.
and the average startup, you probably know this, starts with how much in capital?
So there's a couple different studies, but one that we point to a lot is it's like $70,000.
Right.
Which is not enough to hire 10,000 people or a really good lawyer.
Or maybe even like answer more than a couple of complaints.
Oh yeah, no, absolutely.
Okay, so we're going to ask one more question, and then I'm going to go to question and answer, so please start thinking of your questions. So clearly there are aspects of Cesta and FOSTA that we don't like. But we also all agree that there are bad things on the internet that we wish were not there and would like to remove them. How do we deal with that? Like what if not by changing Section 230, then by what? anybody can feel free to jump in.
So I would just start by saying that Section 230 is what allows companies to deal with bad content online. I always say this on the Hill when we're talking to lawmakers trying to educate them on this. No, very few platforms want bad content. If you have bad content, whether that's ISIS or hate speech or
Fraudulent reviews.
Yeah, fraudulent reviews is a perfect example. Yeah, if you have bad content, you're losing users, you're losing advertisers, you're losing your reputation. No one is sitting there, most people are not sitting there being like, yes, we really want this antisocial content on the internet, and so we're going to leave it up. And Section 230 is the thing that says you can engage in content moderation and not be held responsible. So I would say if we want to fix what's online, the first step is to leave 230 intact. Because that's what protects companies who want to make sure the good stuff is what stays on their platform.
And I wish that kind of more regulators and courts understood that point, because at least from my perspective, I see kind of three kind of potential obstacles for kind of keeping Section 230 intact. And the first is, I think there's a perception that, okay, so the internet used to be this fragile thing back in 1996 and whatnot. It is not anymore. It is powerful, it is a force, it is maybe even too powerful. So you know what, we're not very sympathetic to these arguments about how we're gonna crush the internet anymore. And so I think there's some of that going on. There's also some feeling of, okay, we've had a few years, decades now of the internet, and we've seen how the internet can be used for ill. It didn't turn out to be just this shiny, happy object that maybe we all thought it was going to be. And so there's some of those attitudes as well. And the third is, and I've seen this in some instances in courts and with local regulators, is just kind of a lack of just a basic understanding of what the tech industry actually can and can't do. I have heard more than once things like, well, this is easy. You just push a button. You just flip a switch. You can comply with this. Why is this hard? And so there's a lack of understanding that no, kind of redesigning an entire website or trying on a minute by minute basis to moderate content, that is really hard. It is not just pushing a button and you're good.
And we hear a lot that AI is the answer and this will fix it, and sure, it'll help. Of course, automating things when possible help, but the thing with speech, especially speech online, is context is really important. And an ISIS tweet or Facebook post is one thing, but the BBC retweeting an ISIS tweet is a totally different thing. And treating those the same, which is what an automated system would do, for the most part, is not the answer. There's a very different value there, and so I think we're working on it. We're all working on it.
And from a criminal standpoint, I would say we already have the tools. Human trafficking is illegal. Narcotics trafficking is illegal. Terrorism is illegal. We don't need to invent new ways of taking people to the mat for stuff that's already illegal and it carries really harsh punishments already, and already have the tools to do it.
Yes, all right, good point. With that, let's go to questions. We have a few minutes, and we have a microphone. Yes, in the back. And please announce your name, please, and who you're with.
Hi, my name is Tim Grieve. I'm a journalist currently working with the folks who built Politico. As a journalist, I am completely sympathetic with everything you have just said, but I'll tell you a short story. My son is also a journalist, a college journalist, and in retaliation for his journalism, someone has posted anonymously on a bunch of sites that he's a drug user, a rapist, a date rapist, been arrested for date rape, all these things on these sites that are designed to allow you to report your cheating wife or your cheating spouse. They're like Cheater Report and sites like this. They are the bad actor sites. These are the sites that essentially are all but saying, please post libelous content here. What do you do about those sites?
Who wants to address?
I'm not a lawyer, so I can't address it from the law enforcement side. I mean, I think there's, for the sites that aren't the bad actor, for the sites that do get used kind of because they're open platforms, there are terms of services that they all have. If content violates the terms of service, they're allowed to take it down. I mean, I don't know enough about like libel and slander laws to get into how you go about enforcing them in this case, but I mean, libel and slander are illegal. Not all speech is protected. There is some stuff that we say, no, you can't say that, and so I think that's probably the appropriate venue with the caveat that I am not a lawyer and have no experience in enforcing those laws.
Yeah, I mean, this is going to be unpopular, but freedom of speech has consequences, and sometimes those consequences are shitty things like happen to your son. I also think that there are already on the books things that make that conduct illegal maybe, but definitely liable, and your son could sue and actually get discovery from those sites in order to find out who posted those things. And there have been cases people have won. They've won big cases. So I know that it doesn't satisfy you, but it's the best I got.
Okay. Yes.
I'm just going to yell. Huh? And I'm trying to figure out the right way to phrase this. Is there an intersection here with Citizens United? If someone wanted to weaponize 230 and go after something like that, would this be a way? Is weaponizing the right word? But I've been doing this for like 20 minutes trying to figure out the right way to ask this.
Describe a little bit more. When you say weaponize, what are you trying to accomplish?
Well, people that don't like the notion of spending as speech. So instead of going after the speech or the money, you're going after the platform it's being funneled through. Could you go after PayPal, or if you're receiving, if it's an unpopular candidate according to one political party, could they use 230 to go after that?
I mean, no. I think you certainly see an analogy to that with copyright takedowns, right? Where if your political opponent is using something like a snippet from like one of your ads in their ad, then you can file a takedown notice, and then it gets taken down, and then you have to work through that whole process, right? It just as like a harassment technique. So certainly, I think any vehicle like that could be used for harassment purposes. Anybody else want to? No, but basically this is America, right? So you could sue anybody for whatever you want. Sure. And I certainly, I don't think that's far-fetched. Okay, yes?
I guess just on the same sort of vein, do you think that there is any potential in sort of having a volume? I think everybody's empathetic to a company that would have to comb through so much data to find these examples of people misusing their platform, but for a website that maybe 75% of the content was inappropriate, are there any sort of data volume thresholds that could potentially provide flexibility for companies, but also maybe discourage, being that sort of negative platform?
Sure, I can take a crack at that one. So I would be very careful to, in general, when we talk about startups, we are very careful to set thresholds based on user content volume or number of users, because maybe the smaller platform that in theory has less stuff to sift through and that might be easier, they also only have 2 people. The nice thing about the internet, right, is that you can be a really small team and have a huge reach. And maybe you have a huge reach globally and you don't really even necessarily know who your users abroad are. And so the idea that, well, if there's less stuff or if it's only bad stuff, I don't think that necessarily means a company is equipped to deal with it. But certainly, like I said, we work with companies who are trying to do the right thing. Not everyone is a good actor on the internet. Obviously, that's why we have to have these conversations. And I think the point of using current laws to go after the platforms that are doing bad things or encouraging bad things is that is what happened to Backpage. I think that will continue to be a case prosecutors can make.
Yeah, I think it's an important point that a platform itself, it doesn't get immunity for any content that it itself has created. And so, if a platform, and there was an example of this that Kate alluded to early on, it was called roommates.com. And it had a feature in its website, that matched roommates, that it required users to answer a questionnaire about kind of their roommate preferences in a way that blatantly violated housing discrimination laws. And you had to answer those questions. It wasn't like it was the user had an option or whatnot. And roommates.com, it was liable for that because it was materially contributing to this illegal content and kind of channeling its users into illegality. So Section 230 doesn't protect things like that.
All right, we have time for one more question. Who wants it? Yes.
Hi, my name's Caleb. I'm a software engineer. You guys talked a little bit about the sort of the Swiss cheesing of 230, and to me at least, it seems that a lot of the holes being driven are kind of driven by sort of moral and in a lot of ways noble intentions. So I guess I was curious, how do you open a dialogue with somebody approaching this from a moral perspective and try to help them to understand the far-reaching implications that drilling a hole in 230 would have, despite having a moral good.
Really quickly, an argument that I found very, very persuasive is that you're actually making human trafficking worse. And getting cops on board is helping a lot. So I've been meeting with the Sheriff Association, the Fraternity Order Police, and even the IACP, and they're actually coming, they're getting ready to come out and say, okay, this actually kind of sucks, and it's making police work harder. So that is a very powerful argument. And remember, my role is the criminal guy. So for me, that is a powerful argument for me to make on that issue.
Anybody else?
I would just go back and say that also, I'll make my point again, that 230 is what allows companies to make sure that good stuff and not bad stuff is on their platform. And so as much as stuff will fall through the cracks, and it always does, 230 is the thing that gives companies the safety to actually take down stuff.
All right, what a great panel. Unfortunately, we are out of time. I wish we had longer. But let us have a hand for our awesome panelists.